Yeah, good. Hello, everyone, dear colleagues, students, participants, listeners. The Russian attack on Ukraine in the early hours of Wednesday, a week ago, February 23rd, and the following war in Ukraine have shocked, troubled, occupied many of us as humans, as professionals, as lawyers. The Amsterdam Center of International Law, the Faculty of Amsterdam, has seconded different statements of the European Society, for instance, condemning the Russian act of aggression. I think by now we would also need to condemn crimes of war and possibly other crimes, evidence of which has been fairly clear, unfortunately. The preservation of peace is probably the minimal aim of any legal order, and international crimes seek to protect core values of the international community, outlawing and hoping to prevent what is most abhorrent. Now, it is a fact that the international legal system has not really succeeded in pursuing these aims in face of Russian aggression. And while that's not the first time that the law has failed in that regard, it is still the case that the law continues to structure the discourse about the war and also structures many present practices in the war today and also in tomorrow's continuation. We have the relative fortune at the University of Amsterdam at the Faculty of Law that we can combine great expertise in almost all the fields of international and criminal law that are relevant pertaining to the war. And one of today's objectives for this roundtable is, first of all, to share that expertise, to introduce and clarify some of the main legal rules. I think there are some misunderstandings floating around and some questions maybe that you have, to give you the opportunity to ask them and to discuss them with us and with each other. And there are so many questions about what to do, what can be done with international law. Perhaps most tangibly, what are the prospects of Vladimir Putin to be tried? What possibilities of action, rights, and obligations do the Netherlands or other third countries have? There's a host of questions. And for today, we cluster them, I would suggest, around 4 issues that we take in turn. So we can't be entirely exhaustive, but we can try to touch on many of the main issues at least. I would post the clusters here in the chat for a moment for your orientation, for everyone's orientation. And I would ask that the participants in the roundtable in turn briefly introduce the issue in a short statement, in a short introduction of some 2-3 minutes. I would interview them a little bit interactively and then also open up towards questions from everyone with regard to each cluster. So to ask questions, please type in the chat. You can type your question, or if you want to speak, you can also type in the chat and say, I have a question. If you do speak, please be brief and to the point in your questions and respect the netiquette. Does that all sound quite all right as a way of procedure? If so, then I would start with the first cluster. Also, by way of introduction, I should perhaps just add before I then turn to Marten Zwanenburg and Marieke de Hoon that my name is Ingo Venzke. I direct the Amsterdam Center for International Law. Now, to the first cluster, the jus ad or jus contra bellum, the law pertaining to the use of force, the prohibition of the use of force. And to start with Marten Zwanenburg, a professor at the University of Amsterdam of military law, could you introduce us to the law of the use of force and how Russia engages with that law? How does Russia tried to legally justify its action in Ukraine? Has it actually tried? Has it offered any justification, and what to make of it? Marten, please.
Thank you very much, Ingo, and welcome everyone. It's nice to see that so many have joined us. I'd be happy to, Ingo. I'd start by saying that the Russian invasion of Ukraine is a use of force against Ukraine, clearly. And that means that prima facie, it's a violation of the prohibition on the use of force between states in Article 2, Paragraph 4 of the UN Charter. The only way that would not be the case would be if one of the exceptions to that prohibition applies. And there are three generally accepted exceptions. One is an authorization by the UN Security Council based on Chapter 7 of the UN Charter. The second is consent by the state on the territory of which force is used. And the third is self-defense as laid down in Article 51 of the UN Charter. And such self-defense can be either individual or collective. Collective meaning that other states help a state which is defending itself. So let's look at those in turn very quickly. With regard to a UN Security Council authorization, it's quite clear that there is none. On the contrary, when the Security Council discussed this issue, 11 members of the Security Council wanted to adopt a resolution condemning the invasion, and the resolution was only not adopted because of the Russian veto. With regard to consent, it's quite clear that Ukraine has not given consent for the Russian operation. That would be quite strange. And so finally, we then arrive at self-defense, which seems to be the main justification put forward by Russia, particularly in the speech that President Putin gave on the day that the invasion started. He mainly referred to self-defense. It's not quite clear from that speech whether Russia is invoking individual self-defense, so its own self-defense, or self-defense of the two self-declared republics, which Russia has recognized. So maybe let's take them in turn. If we look at the individual right of self-defense of Russia, this would require that there was an armed attack, or at least an imminent armed attack on Russia. Well, that's clearly not the case. There's no factual evidence at all for that. So such a claim by Russia fails. So then let's look at collective self-defense, a possible justification in which Russia is defending the republics of Donetsk and Luhansk. The problem there is that in principle, only states can invoke the right to self-defense. And it's very, very doubtful that the self-declared republics are actually states, and therefore they would not be able to invoke self-defense, and consequently Russia would not be able to come to their collective defense. And even if that was the case, then use of force by Russia would need to be necessary and also proportional. Proportional meaning, among others, that it needs to be no more than strictly necessary for defending the republics. And that clearly does not seem to be the case. Russia is attacking more or less the whole of Ukraine rather than simply defending the republics. So those are the three generally accepted exceptions. Then sometimes humanitarian intervention is put forward as an additional exception. Russia seems to be at least referring to that when President Putin says that genocide is occurring in the Donbass. However, humanitarian intervention is not generally recognized as an additional exception to the prohibition on the use of force. And it's very, very controversial. And so that also does not seem to be a justification for any use of force by Russia. So thank you very much, Ingo.
Yeah. Very clear, Marten. We will return to the Security Council resolution that was vetoed by Russia in the third cluster as well, since some of you might have seen that it then led to what is called a Uniting for Peace resolution in the General Assembly. If I could briefly follow up with one question to you, Marten, the recognition of the people's republics. So that has received some attention. You also mentioned that, how that may be relevant for any claim of collective self-defense. how does that claim of Russia that these are indeed two separate republics, how does that claim fare in your assessment, or in how has that been received?
Well, it's it's mainly been rejected, although there's some debate on different points. One element, but perhaps others will be able to chime in here, is that for the states, for the republics to become separate states, they would need to secede from Ukraine. And in the post-colonial era, there's much support for the view that that is in principle not possible unless there's widespread violations of human rights of a people in a particular area that wants to secede, or where the so-called internal right of self-determination is being grossly violated by the state in which the people is present. But most commentators seem to consider that that's not applicable in this case.
Mm-hmm. Thank you so much. Marieke, how has Ukraine reacted? So what has Ukraine responded to the Russian acts of aggression? What has Ukraine's legal argument been in this context?
Thank you, Ingo. So there have been many responses, right? And the first and foremost one, especially under the use ad bellum, is of course invoking their right to self-defense. As Marten explained, there are exceptions to using force, because obviously what we see now is that Ukraine is also using force. However, Ukraine has a legitimate basis under public international law, because as Marten explained, the prohibition to use force, Article 2.4, has these exceptions, and one of them is the right to use force, Article 51 of the UN Charter, but also recognized as a customary international law norm. So Ukraine has this right to self-defense and can therefore respond. And there's also, indeed, as Marten said, the right to collective self-defense, which means that under the UN Charter, under public international law, all states can come to the aid of Ukraine to help fend off this armed attack, armed invasion, aggression by Russia. And I wanted to add also to what Marten said, I fully agreed, like the basis, the legal basis for humanitarian intervention, as Russia is trying to imply, is very weak. And so currently under international law, we do not recognize the right to humanitarian intervention as a justification for using force. And I think it's also important to keep on emphasizing that even though Russia was claiming that genocide was being committed and claiming that these human rights violations were committing, there's also no evidence that it was actually happening. So even if it were sort of debatable, in this case, is also not the facts. And this is probably, I think, the most interesting or important point to sort of, before we move to the other speakers, is that what we see here is an armed conflict that's not just fought with weapons, but also one that's fought with both information and disinformation, and with law, with the language of law, making our discipline so very important. It's lawfare what's going on by Russia's manipulations of all these justifications to resort to force. It's setting this, like it's manipulating the law and trying to come across as if it were justified. And then very interesting, what you see Ukraine do is again sort of taking up also these weapons of law and trying to fight in all these different institutions that the different colleagues are going to address.
Mm-hmm. Yeah, very interesting. Also, the attention that you draw, as has been noted a couple of times, to the communication dimension, to the media dimension, perhaps even more specifically to the social media dimension. You see both sides making very targeted efforts in that regard. If I could also, with you, Marieke, follow up with one question. If the law is in that sense an instrument of lawfare, as you said, instrument of legal extension of warfare, what is the possibly remaining role of the law in a way as arbiter between competing claims? So who then is to say that who is right and who is wrong, if they both are so apt at casting their claims and their objectives and their actions in the glass of international law?
Yeah, I think that like law is always difficult as a mediator between conflict of interest. And what we see so often in international law is that many of these norms are quite open and vague and gray and open to interpretation. The striking point, the striking aspect of this war is that it is so clear. It is actually, this is a war where it is so black and white. And I think then the importance of engaging in legal norms, I think it's really, a lot of people will say, and I understand totally that reasoning. So what does it matter? Law, because Putin is not going to be stopped. It's not going, it's just doing what it does. But there, I think it is especially important that we lawyers engage also in that debate to set that norm. I think if we now would not engage and just like say, you see the international legal order doesn't work, then we would also sort of let it be. Whilst quite the contrary, if we then engage and we emphasize the norms, we are also strengthening the international legal order, helping fight that disinformation, fight that manipulation. And I think it's therefore really good that a lot of different courts are now giving the podium to try and engage in that debate as well. Hopefully, maybe reaching some of the military commanders and making them maybe second guess.
Yeah. Thanks, Marieke. I see that our colleague Terry Gill also wants to chime in, and we would make him co-panelist for that purpose, and that's right on time. Terry, exactly. We can't see you, but we will be able to hear you now. You also wanted to add to what Marten and Marieke have said on the use ad bellum.
Yes, thank you, Ingo. I'll try to be brief. I'm actually in the process right now of writing a piece for the Articles of War blog at West Point on the justifications put forward by Russia. So this is sort of on a roll, as it were. What Marieke just said is, I think, absolutely spot on. The discourse here, the way that law is being manipulated by the Russian Federation to try to justify their invasion of Ukraine is, I think, almost a textbook example of what is referred to sometimes as lawfare. That doesn't mean that the law is irrelevant. I would say, on the contrary. If it weren't a point of reference that the government of the Russian Federation thought was important to try to enlist on its side, then it wouldn't take the effort to do so. It would just say these norms are totally irrelevant to us. We'll just go ahead and do what we think is important to do. But they have actually spoken, at least attempted to, in the language of the law, with, I think, little success, and rightly so, because this sometimes, you were talking just now that saying, well, these norms are sort of elastic or gray and they're open to interpretation. Yes and no. I mean, I think that the core elements of the jus ad bellum are fairly well established. I think the vote in the Security Council made that clear, and the vote in the General Assembly made it clear too. And there are, of course, differences of opinion on various issues. Some people will argue that humanitarian intervention is a technical violation of Article 2.4, but doesn't constitute aggression, like my friend Klaus Kress. Or there are people who will say, rescue of nationals in particular situations is not a violation of Article 2.4, while others say it's always subject to abuse and therefore should be rejected as a modality of applying self-defense. But the core issue here is that a sovereign state's very existence is being denied. Its right to independence and sovereignty is being denied. It is being subjected to massive military force, and without any threat of attack even not even a possible preemptive. So there's no, I don't think, any room here for reasonable people to disagree on issues which have been debated. This is a cut and dry, clear aggression.
Yeah.
As to the other possible justifications that have been put forward, I mean, I would just add, consent by a state's government to use force on its territory isn't, I don't want to be, picky-uni, but I wouldn't view it myself as an exception to the Article 2.4 prohibition. It's an attribute of sovereignty. The state has the right to allow another state to conduct a military operation on its territory, but that is not an exception in the sense that it would allow force to be used against another state. So if, for instance, the Democratic Republic of the Congo consents to a UN peacekeeping operation to maintain stability and protect civilians, there's no question of Article 2.4, the principle of intervention being violated there. In that sense, as long as the invitation is valid and not undertaken with coercion. But be that as it may, I mean, the collective self-defense argument that was put forward that Marten addressed, I agree with him completely. I mean, you only have the right to collective self-defense if you're a sovereign state, and there's no grounds for viewing either of those two breakaway republics as sovereign states. I mean, in fact, the Russian Federation didn't even recognize them as such until 24 hours before they initiated their invasion. So that would seem to be a rather clear case of okay, we now recognize you as a sovereign state, and by the way, we want an invitation to come and protect you. That's such a almost, that doesn't even require, I don't think, a long discussion about whether that's legal or not. And finally, humanitarian intervention, although it's been discussed back and forth, as was pointed out, I mean, that only would be an issue. Even the Russian government is talking about things like their language rights of the Russian minority not being respected, or the right to vote on the presidential elections by the Russian-speaking population in the two breakaway areas was not given, rather understandably, if it's in the middle of an armed uprising. But the question of genocide, which is the usual tripwire for, or massive crimes against humanity for even those who believe in humanitarian intervention, hasn't even been, this Russia has claimed that. But if you look closely at what they're talking about 4 million Russian-speaking citizens of Ukraine who are apparently, in their view, being subjected to genocide with no evidence for that whatsoever. It's interesting to see that the cities that they've now taken control of in the south are predominantly Russian-speaking, and the one they're fighting over right now, Kharkov, as well. It should be crystal clear to every reasonable observer that a large segment of the Russian-speaking population of Ukraine is just as fiercely involved with the resistance against this invasion as the Ukrainian-speaking portion is. So the plea of humanitarian intervention fails both in terms of the legality and as not being a recognized exception, as pointed out, but it also misses any factual basis whatsoever.
Yeah, very clear. Thank you so much for that, for those additions, Terry. I do want to pick up a few of the questions that have been posted in the chat by participants and direct two of them to Marten to start, namely those of Adelina, who asks and would allow you to clarify the point on collective self-defense. So how can the Russian action possibly be justified as self-defense? How did that argument go? I mean, you didn't make that argument, but just the possibility to flesh it out again. And then foreshadowing a bit towards the next cluster, the question by Jia Liu, the distribution of weapons to civilians on part of the Ukrainian government and military. What implications does that have for the treatment of civilians? Are they then treated as human shield? Do they lose their protection? What to make of that fact of distributing the weapons to the civilians? Marten.
Thank you, Ingo. With regard to Adelina's question, I think there we can again distinguish between individual self-defense and collective self-defense. And to start with the latter, I think it's good to point out that the Russians have not very clearly, they've indeed tried to enlist the language of international law. Having said that, they haven't very step-by-step clearly tried to provide a justification. So I think that's important to point out. But one could derive from what they have said two possible arguments. One is that having recognized the republics, those republics fighting with Ukraine, that the fighting would constitute an armed attack by Ukraine on the republics, which would then give the republics the right to individual self-defense, and at their request give Russia the right to collective self-defense. That would then be the argument. But again, as I stated before, I don't think that that flies. On individual self-defense, as I said, a self-defense requires a prior armed attack. Now, traditionally, an armed attack means actual use of force crossing the border. There is quite a large body of opinion which accepts that an imminent armed attack is also an armed attack and justifies self-defense. So that would be the situation where there are large numbers of forces on the border which seem ready to cross the border at any moment. The Russian buildup prior to the invasion is a good example, I think. And then there is a much more controversial theory of preventive self-defense, under which the actual threat is much further removed than actual forces on your border. But it's an argument that has been made in the past by the US, for example. So possibly the argument would be by Russia that NATO actions are building up to what would eventually be an armed attack, and Russia needs to act now because it could not do so later. So with regard to the question on handing out of weapons to civilians and how does that relate to human shields, I think there are two issues there, and I won't go into too much detail because there's a lot to be said about that. One is the question whether we're dealing here with a so-called levée en masse, and how handing out weapons by the government relates to that. A levée en masse is when civilians spontaneously take up arms to resist an invasion where there's not been time to organize this. So an interesting question is whether we're dealing with a levée en masse, which some in the past have argued was becoming a dead letter. With regard to human shields, I would say that if civilians are given weapons and if they start to use those weapons, then they are what is called under IHL directly participating in hostilities, which means that they're now a legitimate target to be attacked, and they no longer enjoy the protection from attack that civilians normally enjoy, and therefore the question of human shields would no longer really arise.
Yeah. Thank you, Martin. Then there are a few questions that pick up on the debate about lawfare, about the instrumental use of the law, but also then on comparing the Russian aggression against Ukraine last week and ongoing, and the use and the justifications there to other prior breaches of the prohibition of the use of force by Western states, by the NATO in the bombing of in Kosovo, but perhaps also other instances, the war in Iraq and others. If I could give those questions, and also then the question, the first one that was asked by William on the usefulness of the binary use of legal, illegal when it comes to breaches of the prohibition of the use of force, and the question of whether other additional criteria would need to be added to say what is legal, what is illegal. Marieke, and then I would from there move to the second cluster, and we can still weave in some of the questions as we continue. Marieke, please.
Thanks. Yeah, I think for the comparison with the NATO 1999 bombings, it's relevant that there was an actual ethnic cleansing going on there. So there were serious human rights being violated. When NATO was bombarding, there were also international lawyers looking at that and concluding that it was unlawful but legitimate. And so there was this conversation about, well, to what extent is it aggression if you're actually protecting human rights? So this is a type of rationale that Russia is also trying to invoke, but therefore it's quite crucial that, first of all, that was very debatable whether that was lawful, but it was sort of seen as okay, or at least legitimate by a lot of countries, including the Netherlands, when recognizing Kosovo as an independent state by saying, well, in that situation, we believe the Netherlands recognize it on a basis of a basis in like a remedial secession. This is really debatable in international law, and that's why you're studying international law, because that's gray, complicated, but this is not such a gray topic. And I think that's also where I want to respond to Terry's remark on sort of like the clearness. So I can imagine a lot of people are also asking about the crime of aggression, right? To what extent is this not then a crime of aggression? And here you see, for instance, the language, I think it's quite clear that it's aggression. But when the crime of aggression was being drafted, it became already more complicated because it referred to the crime of aggression is the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or direct the political and military action of a state of an act of aggression. Well, so far you could see, well, the leaders of this aggression could probably fall under this definition of the crime of aggression. And then it says, which by its character, gravity, and scale constitutes a manifest violation by the UN Charter. And this is where people argue, I argued in my own PhD, will be a lot of debate on what then is a manifest violation and not. And so if we looked at NATO bombarding, then the arguments would be, yeah, but that's not, maybe it's a violation of the UN Charter, but it's not a manifest violation of the UN Charter, and that's why it's not a crime of aggression. Whilst in this case, you probably would say, well, actually, it wasn't a humanitarian intervention, legitimate, so this actually is a manifest violation. So in that sense, you can say this is a crime of aggression, and then bridging to our next section on criminal justice, you would say, so the International Criminal Court can prosecute Putin. But there we have a problem that it actually, Article 15 bis, paragraph 5, excludes the jurisdiction of the International Criminal Court over aggression because Russia is not a member state. So yes, it is a crime of aggression. In this case, really not so difficult. It was much more gray with the NATO, but the ICC is limited to actually act against it.
Great, very clear. Thank you so much, Marieke. And it's indeed a wonderful bridge to our next cluster of issues, namely the responsibility of states of Russia in particular, but perhaps also of co-belligerents, of Belarus, of other countries. What are the responsibilities, possibilities there, but then also indeed of criminal individual responsibility, not of the state, not of Russia, but of individuals, of Putin, the political, the military leadership, but perhaps also the soldier in the field who is takes part in committing a war crime or another international crime. So to proceed in that order with short introductions by the Dean of the Law Faculty, André Nollkaemper, Professor Göran Sluiter of Criminal Law, and Sergey Vasiliev, also of Criminal Law, in that way. André, please.
Okay, thank you, Ingo. So I will make a few comments on the responsibility of the Russian Federation and maybe one on Belarus. So a few points. One, following directly on the comments by Marten Zwanenburg, it's clear that a series of wrongful acts have been committed. Attribution is not a problem. So clearly here we have a case of responsibility of the Russian Federation. Earlier this week, I believe on Tuesday, the Institut du Droit International, of which I happen to be a member, adopted a resolution that stated in so many words that the international responsibility of the Russian Federation is engaged for its serious breach of obligations arising from violations of peremptory norms of international law. And that as such, Russia exposes itself to appropriate measures and so on and so forth. So the main question here for the law of responsibility is how that body of law channels these responses to violations of peremptory norms. So there I make 3 points. One, we have at least 2 claims made by Ukraine against the Russian Federation in the courts. So we have the claim in the International Court of Justice, to which we may come back later, in which Ukraine has asked the courts to adjudge and declare that the invasion by the Russian Federation is based on a false claim of genocide and therefore has no basis in the convention. It's a bit implicit in that claim whether or not it is a claim of responsibility or just a matter of interpretation. But a bit further on in what Ukraine asked, it's quite clear that what they are looking at are claims of responsibility, because the court is asked to order the Russian Federation to provide assurances and guarantees of non-repetition and to order full reparation. These are clearly consequences of a prior finding of responsibility. We have to see next week how this will fare in the Hague in the Peace Palace. Second case is the case brought in Strasbourg by Ukraine against the Russian Federation. Last week, the European Court of Human Rights ordered provisional measures and ordered the Russian Federation to protect the rights of the civilian population and thereby to protect Articles 2, 3, and 8. Technically, again, not a determination of responsibility, as we are only in the provisional measure stage, but clearly what is at issue here is eventually a determination of a wrongful act by the Russian Federation and legal consequences. Second set of consequences, more to the point perhaps, are the consequences that the law of responsibility attaches to violations of peremptory norms. So here we are for the those of you who read in detail the law of responsibility in Article 41 of the articles by the ILC. And the legal consequences are clear. All states are obliged, all other states, I should say, are obliged to cooperate to bring to an end the violations of jus cogens by the Russian Federation. And all states are obliged not to recognize the legal consequences of that invasion. I think this is very clear that this is actually the position taken by the large majority of the international community. But to the extent needed, this body of law would actually provide a legal justification for the acts of cooperation and non-recognition that we now see. This set of the law of responsibility also relates to Belarus, because this Article 41 also obliges third states, including Belarus, not to aid and assist in any way states that engage in the violation of peremptory norms of international law. So to the extent needed, if there would not be another basis, this would be a clear basis for the responsibility of Belarus for a violation of international law. And thirdly, perhaps most importantly, this body of law of responsibility provides the legal basis for the sanctions and more generally countermeasures adopted by a large part of the international community. So here we're looking at third-party countermeasures, and of course, it's a mixed bag. Some of the sanctions that have been imposed do not as such appear to be in violation of international law, but others appear to be. And to that extent, you actually need to rely on the law of responsibility to justify those third-party countermeasures. Now, we know that for some states, it has been very controversial whether third states actually could rely on countermeasures in the public interest, quote unquote. And certainly Russia and China have taken and still take the position that it is not allowed and it is only a matter for the Security Council to adopt these types of countermeasures. But what we see here is that in the absence of the ability of the Security Council to act, the large majority of the international community actually accepts and adopts the right to take countermeasures and thereby acts in place, as it were, of the United Nations to respond through sanctions to the violation of peremptory norms by the Russian Federation. Of course, that may interact with what the United Nations itself will do, and Dr. Brölmann, I think, will talk on this later on. Okay, Ingo, back to you.
Yeah, great. Thank you so much, Nollkaemper. The last point is indeed, if I could tease that out, very decisive, I find. As you've explained, there has been long-standing controversy in the law of state responsibility, what the rights, more so than the obligations on third parties, so a third party that is not directly injured, what their rights may be. So for instance, the Netherlands, other third parties, especially in view of a violation, not of any norm, not of any violation, any wrongful act of international law that makes Russia or the wrongfully acting state responsible, but more specifically of a violation of a peremptory norm of international law, the so-called Jus Cogens norm. And there's been indeed that openness as to whether a violation of a Jus Cogens norm would allow a state to take countermeasures that would otherwise violate international law. And so you say now that there is indeed that movement. The International Court of Justice was also ambivalent and left that question open. And you say now there's increasing clarity that that is indeed the case in this present context, that the Netherlands or other third countries can take countermeasures that violate international law prima facie, but that are justified as a response to a breach of that peremptory norm of international law.
Yeah, well, I would add one word of caution, and because it's very early in the game. So we have seen European practice, United States practice before, invoking the right to take collective countermeasures in the public interest, and we have seen resistance by China and the Russian Federation before. It appears from what I see, but we have not been able to analyze the positions of all states on the sanctions that are currently being taken. It appears that the shift towards a general recognition that this is actually allowed by international law is now wider than it was in the recent past. But again, we see a continuous opposition by some states. So I think the jury is still out there, and we have to, once this is a bit over, to look carefully at the practice of states and the protests perhaps of some states to see how this filters out. My tentative assessment now is that the support in the international community is wider than at any earlier stage. And that actually we might see this as a shift towards a general recognition that in these cases of violation of peremptory norms that are generally condemned by the international community, a right to take third-party countermeasures would indeed exist.
Could I ask one tiny question? Also with regard to third states, I've heard some people being concerned about the provision of weapons by the Netherlands, by Germany, by other countries to Ukraine. One quick question could be, does that turn these third countries into co-belligerents? Does the law of responsibility have a role to play in addressing the legality of the provision of weapons to Ukraine?
Yeah, so the law of responsibility has only very little to say on this, actually. It only will say that if the Netherlands would provide weapons to Ukraine, and if these were to be used for breaches of, say, IHL or human rights, then under certain conditions that might engage the responsibility of the Netherlands. Whether it would actually make the Netherlands a co-belligerent in the case, I would actually prefer to turn to Marten Zwanenburg back, but I leave it to you, Ingo, to see whether you want to move in that direction.
Very briefly, do you have a view on that, Marten?
Yes, Ingo, thanks. I think on that question, the law of neutrality, which is part of IHL, is directly relevant, perhaps more so than the law of state responsibility. Under the law of neutrality, there's a view that traditionally states that are not parties to the conflict may not aid or assist another party, let alone fight with them. In this case, it's been argued that either it's possible to be a qualified neutral, which means that you can assist another state, which is a party to the conflict, just so long as you don't fight with that state. And so therefore, sending weapons to that state would not be in breach of neutrality. And then there's also an argument that in this case, the Netherlands could come to the collective self-defense of Ukraine and could on that basis use force. And that if the Netherlands is allowed to use force, then it must also be allowed to do lesser things such as provide weapons.
Thanks for that clarification. Perhaps it was inevitable, but we're running a little bit behind the schedule. We have the important issue of individual criminal responsibility as a cluster now with Sergey Vasiliev and Göran Sluiter, experts in the fields of international criminal law, transnational domestic criminal law. Who of the two of you would introduce the issue first? Yeah, Sergey, please.
Good afternoon, everyone. Can you hear me?
Yes, very good.
So yeah, criminal law is, of course, the ultima ratio tool that is deployed when everything else has failed. It's not the first or even second thing that springs to minds of people who are caught in an ongoing humanitarian disaster we're now witnessing in Ukraine. But ultimately, criminal justice, it will be pursued and certainly pushed for by victims, because what we see in Ukraine, the civilian infrastructure is being deliberately attacked. Civilians are targeted by indiscriminate weapons in densely populated areas. Those who did not manage to catch the last train from Kharkiv or Kiev, they find themselves basically in a siege situation. Thousands have lost their lives or were wounded. Hundreds of thousands of homes have been destroyed. People have no access to drinking water or very limited access. They spent nights in makeshift shelters in subway stations, old people, women, children, their pets. So as human beings and legal professionals, we cannot but feel really helpless observing this from the position of comfort and safety. But nevertheless, let us adopt the framing of international criminal law and individual responsibility, which is, of course, relevant considering what is happening in Ukraine. So first of all, on crimes, the crime of aggression or crime against peace has already been mentioned. We can say with full certainty that the commission of this crime was started by the Russian leadership already in 2014. It continued in the course of following years and took on another dimension of conventional war and armed attack on the 24th of February. This crime is continuing due to illegal annexation and occupation of the Crimean Peninsula, and also the Russian government's sending armed bands and gangs to fuel separatism in the Donbass. The crime is also continuous in view of the multiplicity of distinct instant and continuing acts which amount to the crime of aggression. But this is a crime which at present does not have an international court with jurisdiction over it, as Marieke has already mentioned. There's also been credible evidence emerging of war crimes, so massive shelling by the Russian armed forces of the Ukrainian metropolises, leading to destruction of residential neighborhoods, administrative buildings, schools, museums, memorials, including the Holocaust memorial at Babin Yar. So imprecise, inherently indiscriminate weapons are being used to shell civilian objects. Unguided missiles, cluster munitions have already been used, and this is confirmed. And also the thermobaric weapons, so vacuum bomb launchers, were spotted in the conflict zone. The use of this weaponry is obviously contrary to the principles of distinction and proportionality. These are clear serious violations of the laws of customs of war and the applicable conventions which amount to war crimes. As for crimes against humanity, The Russian army now in the Ukrainian territory basically consists for a large part of a very young, 18, 20 years old, and poorly trained soldiers who were not even aware where they would end up, and that they would be sent basically to a war in Ukraine. Many were conscripted into the army to serve for 1 year, which is a legal duty, but then they were forced to sign service contracts and sent to fight in Ukraine. So they basically expected to be met with flowers as liberators of the country from the neo-Nazi and drug addict clique that occupied Kiev. But instead, they are faced with Russian-speaking, very angry and as yet unarmed population that really hates them. So the soldiers are poorly fed, demoralized, they do not understand what they're even doing there. This is a recipe for disaster in terms of the crimes against humanity. Not much time will pass before the soldiers turn against and start murdering, torturing, raping, committing other inhumane acts against civilians as part of a widespread and systematic attack directed against the civilian population. So there is a high risk there. Then some commentators also fear that the rationalization and justification of the war against the Ukraine that were used by the Russian government, by the top leaders, including Putin, really contains the seeds of genocidal thinking. And those seeds may grow as the conflict continues and as the Russian army gets stuck in Ukraine for long. As Putin said, Russians and Ukrainians are one people. So he basically wishes to eliminate the Ukrainians that fight against the invasion because those are the bad apples, neo-Nazis. Good Ukrainians are indeed Russian-speaking Ukrainians, and they must be ready to succumb and pledge allegiance to Russia, or rather the Putin regime. This is potentially a downward spiral because there seems to be a certain ideology at work, at least in the top echelon. So if that ideology is ultimately adopted by the troops on the ground, this might potentially create a genocidal situation. I could also address potential avenues for accountability, but perhaps I need to stop here and pass the floor to Göran.
Thank you, Sergey. Indeed. Briefly, Göran?
Yes, thanks, Ingo, and good afternoon, everyone. A few points before I start. However, I want to give a brief disclaimer for those who do not know me. I also work as a lawyer at a human rights law firm. Yes, criminal justice and individual criminal responsibility. I think what we will see the coming months, years even, is a huge activity in various criminal justice systems in relation to this conflict. I think there are three levels we could look at. First, the international level, the ICC, few observations there. Then national systems, a few words on the Dutch system, and also things at all national criminal justice systems that have not yet been connected so strongly to this conflict and to the crimes committed in relation to this conflict. So which I would refer to as the hidden level. Obviously, everyone is looking at the ICC. The prosecutor of the ICC has issued a statement that they will start the investigation, and the case has been referred by 37 countries to the ICC. So the ICC has to start and will start its work. Of course, the ICC does not have jurisdiction over aggression, which has already been mentioned, and which really is a serious problem or shortcoming. It would be ideal to have aggression there, also because it's a very, very easy crime to prove, and one could have really swift and expedited justice and immediately point towards the leadership accountability for that crime. There's war crimes left. However, there is a limitation in the statute that the jurisdiction over war crimes is limited to, in particular, when committed as part of a plan or a policy or as part of a large-scale commission of such crimes. So not every individual war crime will therefore be within the jurisdiction of the ICC. So that's a threshold we have to bear in mind. But the most difficult problem for the ICC is, of course, the scarce resources and also the lack of cooperation from the Russian Federation and the inability to have a case in the absence of the accused. We have seen that with other tribunals, the Lebanon tribunal, and of course the Nuremberg tribunal, they had cases in the absence of the accused. In the Netherlands with MH17, we have cases in the absence of the accused. And if we really want to have expedited justice and to have these proceedings to progress, then this could something be maybe in the future for the ICC to reconsider. Let's also look at the Dutch system. Of course, the Dutch system cannot immediately indict Putin because there's an immunity under the Dutch law for state immunity for sitting heads of states and leaders of governments. However, the Dutch system has a number of advantages. For example, we have the full jurisdiction over the crime of aggression. And also we have jurisdiction over corporations, over legal corporations. And also we do not have the threshold for war crimes. So every war crime can be prosecuted in the Netherlands on the International Crimes Act. So the Dutch system, like other national justice systems who have incorporated the international crimes in the ICC statute in their domestic system, they can start investigations. Not so much for domain perpetrators, because we can fear that they will be relatively safe in the Russian Federation, but for the group of possibly companies who are supportive of the current regime. And I think these companies should at many levels be worried to not to be engaged with any Russian criminal occupation or annexation of Ukraine. To give an example, the crime of aggression also includes the illegal occupation and annexation of Ukrainian territory. And contrary to the ICC statute, it is not limited in the Netherlands to a leadership crime. It is a leadership crime for the main perpetrator, but a company aiding and abetting an unlawful and illegal occupation of Ukraine can be prosecuted in the Netherlands. And I think these companies should not doubt the resolve of, for example, certain law firms to file these criminal complaints with the Dutch prosecution service. Then finally, a few words on what I would mention as the yet a bit hidden level, not so much in the media attention. And that is, for example, criminal liability for non-international crimes. There's already a lot of discussion about how can we take away property from oligarchs, and that it's not legally so easy. But of course, we have a number of crimes in our box that have not yet been used enough in the past. And this is a wake-up call to use them in a better and more effective way. And I'm especially thinking about such crimes as money laundering. I know that in respect of Russian oligarchs who have obtained their wealth already unlawfully in the past by criminal means, there have been a series of criminal complaints filed in Europe, for example, by Bill Browder, who is the person who is activating the human rights activist, former businessman in favor of the Magnitsky Acts. And these criminal complaints have been filed in different countries, and they have been progressing too slowly. And I think this can actually be a wake-up call to look at money laundering and effective prosecutions for money laundering, not only as important to safeguard the integrity of the financial world, but also that we view money laundering as a crime that is actually benefiting and supporting major human rights violations and international crimes throughout the world. And I'm really confident, actually quite confident that we will something like effective prosecution of money laundering. We will see it more and more often in the future, in these type of also to prevent these type of situations and to cut off the support, the financial support for international crimes and this type of acts of aggression. So, thanks.
Very interesting. Yeah, thank you so much, Göran. Just also both of you then for mapping the repertoire or toolbox, as you put it, of criminal law and mechanisms to counter international crimes, but also other crimes that contribute to mass violations of human rights and sustain wars, such as money laundering. Some of the participants, some of you might have seen that several countries, Canada, then I think now the number is up to 30, 40, perhaps even have referred the situation in Ukraine to the prosecutor of the International Criminal Court. Could one of you explain what's up with that? So what does that referral mean? What possibilities does the prosecutor now have to investigate the situation in Ukraine? And if you could connect to that, the question that Jonathan Quick asked in the chat, what mechanisms are there, safeguards to ensure that the evidence that is collected at the moment by Ukraine with regard to the alleged war crimes is actually reliable, accurate, and that the procedures based on that will be fair? Sergey, you unmuted yourself. You would go first.
Yeah, sure. So concerning the referral by now 39 states, referral by state party is one of the trigger mechanism which allows the court to start exercising jurisdiction. It is a trigger mechanism for the exercise of the jurisdiction as such, where the court already has jurisdiction in principle. It was one of the potential avenues for the ICC prosecutor to commence investigation, and he was considering several of them in view of the urgency of the situation and the gravity of the crimes that were allegedly committed. So one of them would be the proprio motu avenue under Article 15.3, but it would require the prosecutor to seek authorization from the pretrial chamber to open an investigation, which would take normally at least several months to obtain. And then the decision would probably be issued only in let's say 4 months, and a lot of time would be lost. The prosecutor would only be able to take measures to preserve evidence in Ukraine without having actually started the investigation. So then the second avenue was chosen, namely state referral, because the prosecutor in his statement several days ago hinted at it in his address. So he basically invited states parties to refer the situation in Ukraine to his office. And the first referral was done by Lithuania. And there was some misunderstanding, I believe, because Lithuania first submitted a communication under Article 15.2, which does not trigger investigation as such. It is mainly information about the crimes that are being committed. And then in response to invitation by the prosecutor, Lithuania transformed this communication into a formal state party referral. And then 38 further states parties followed suit, and they filed a letter saying that we also support a referral. So now the prosecutor has officially started an investigation, and the investigative team has already been dispatched to the region of Ukraine, as the prosecutor phrased that. But I think in terms of the investigation, we should not hold our breath. It will take a lot of time, I believe, before the OTP can put together viable cases against specific individuals on its own, in view of the fog of war that prevails now on the ground. And I'm not sure how much time they would actually be able to spend in Ukraine itself because of the ongoing conflict. On the other hand, I also do not exclude the possibility for Ukrainian authorities to, for example, surrender to the ICC any mid-level commanders or even low-level alleged perpetrators that they managed to capture. The big question is, of course, whether Karim Khan would have the courage to issue an arrest warrant against Putin or other prominent actors in his government. This would certainly complicate any peace negotiations that may be ongoing. It would probably worsen the situation on the ground, and in Russia, where you could also say that crimes against humanity are being committed at the moment. Perhaps Putin would adopt a Hague Invasion Act, we do not know. But I do think that he needs to, he should consider issuing a sealed arrest warrant.
So Göran, the court, the International Criminal Court, thanks, Sergey. The International Criminal Court in principle has jurisdiction over war crimes, the crimes against humanity, the crime of genocide, and since the amendment of Kampala, also over the crime of aggression, but not in the present case, right? So why not in this present case?
So yeah, so sorry, Ingo, if I may also, you mentioned the question on the chat regarding the collection of evidence and the quality of evidence. So very briefly on that, that's a very good point, because ideally one does wish to avoid litigation on the admissibility or probative value of evidence. And actually there are a number also of investigation mechanisms for Syria and for Myanmar, and they are preparing the collection of evidence for possibly future criminal trials. And one of them at least is working on rules of procedure and evidence, some sort of best practices, so rules that also then could be used maybe elsewhere if you are in this type of situations and you want to collect evidence, how to do that, what to take into considerations, how to protect the chain of custody, etc., and to preserve authenticity. And actually that would be very helpful, not only for this conflict, but also for other conflicts. Mm-hmm. And regarding crime of regression in this situation, why not here? And that's the restrictions for jurisdiction. Actually, I had the pleasure and privilege to also be present at those negotiations in Kampala, and it was clear from the beginning that there were many states also opposed to the court being in an effective position to effectively prosecute the crime of aggression. So it was a bit of a give and take, and I think the relatively solid definition we have of the crime of aggression, so that has not been watered down, came at the price of a strong jurisdictional protection for the powerful states. So the jurisdiction is only possible via the Security Council, which the Russian Federation, of course, can always veto, or if both the state of the nationality of the accused and the state where the crime was committed have ratified the statute or have accepted the jurisdiction. So, so nothing can happen. Simply nothing can happen at the ICC without the acceptance of the Russians, which is not there now. But if one is optimistic and would hope for regime change, this is of course something that hopefully, or who knows, could take place in the future. But for now, it's totally blocked.
Thank you so much, Göran. So much more to say on the individual criminal responsibility and how to pick it up, how to enforce it. We do need to move on to the next cluster of political and judicial procedures of dispute settlement. There have already been quite a couple of questions in the chat for Dr. Brölmann in particular, specialist in international organizations, law, among other fields, on the legality of the Russian veto, even the legality of the succession as has come forward at the moment. And what about that much cheered, at least in my Twitter bubble, resolution that is called the Uniting for Peace resolution? Yeah, without further ado, Kiki, would you introduce us to that first part of the cluster?
Okay, let me put my my timer. So yes, thanks. Let me then recall three salient moments, let's say, in the UN process over the last week. On the 25th of February, so a week ago on Friday, the Security Council voted on a draft resolution regarding the war in Ukraine. It was vetoed, not unexpectedly, by Russia. Otherwise, 11 members voted in favor of the text and 3 abstained. Those are China, India, and the United Arab Emirates. Now, the actual voting was delayed because of last-minute negotiations with China to amend the text Kenneth, Manusama, and Margarita, they have already been chatting about this in the chat. They have been talking about it, and indeed, some chapter 7 language has been taken out at the last moment from the resolution text. So, and also it now did not condemn Russian aggression, but it deeply deplored or something. So certain linguistic tweaks have been made to secure China's abstention rather than negative vote. So that was successful.
And just
Then
to clarify,
2 days.
chapter 7 is the chapter on the use of force.
Yes,
But
yes.
what was taken out is any suggestion that this condemnation of
enforcement.
deploring could possibly be taken as a Security Council authorization
Yes.
of the use of force, which is separate, as Marten started out, from other bases for the use of force.
Yeah.
Sorry if I interrupt.
No, this is very good. So chapter 7 is enforcement, even with force and without force, so overriding state sovereignty. Chapter 6 is specific settlement of disputes. So there have been navigating between these poles, you could say. On Sunday, then, the 27th, the Security Council adopted a resolution calling for a so-called emergency special session of the General Assembly. So the matter was referred to the UNGA, the plenary organ. This is rare practice. It is, in fact, as Ingo was mentioning already, it is a so-called Uniting for Peace resolution, the 11th time since the original one in 1950, which was adopted in the Korean War when the Security Council was paralyzed, as people would say. The Uniting for Peace resolution states that, and they follow the language, the Security Council, when it fails to exercise its primary responsibility to act as required to maintain international peace and security, in that case, the General Assembly may consider the matter immediately and may issue appropriate recommendations to UN members for collective measures. So recommendations, of course, has some importance here in relation to the Assembly because it lacks the power institutionally, legally to take enforcement measures a la Chapter 7 in the way of the Council. Now, the same 11 members voted in favor, the same ones, the same states abstained, and this time, crucially, no Russian veto because resolutions referring matters from the Council to the Assembly historically have been viewed as procedural matters, which means that they are not subject to a veto, Article 27, paragraph 2 of the Charter. So there was a little tricky backdoor that has been built in early on. Then I'm skipping now some reflections that maybe there's room for later, but then on the calendar, let's say last Wednesday, March 2nd, the General Assembly itself has adopted with an overwhelmingly positive vote a resolution which deplores in the strongest terms the aggression by the Russian Federation against Ukraine, end of quote, demands immediate cease of hostilities, of violence. It demands an unconditional and immediate withdrawal of all military forces. So quite strong language also for a General Assembly resolution. 141 states, so that is quite a historical result, voted in favor of the resolution, 5 against, 35 abstained. The countries, those 5 countries, so the countries to give a negative vote together with Russia were Belarus, Syria, North Korea, and Eritrea, so quite the band of friends. China abstained. And to reiterate a formal point, Assembly resolutions are not legally binding, of course, but obviously can be immensely weighty. And also in this case, and the voting pattern reflects the global outrage at the Russian attacks. Interestingly, for example, 6 of Moscow's allies who stuck with Russia in 2014, when there was a similar vote in the Assembly after the annexation of Crimea, this time they abstained. So Armenia, Bolivia, Cuba, Nicaragua, Sudan, Zimbabwe. Another supporter, Venezuela, had no right to vote because of unpaid membership dues. And very significantly, Hungary and Serbia, European countries with arguably the closest ties to Russia, they voted for the resolution. So, a lot to say about this, but it's quite a historical thing, although obviously not with an immediate effect, perhaps. Yes, let's leave it at that.
Thank you, Kiki. And how about the point of Russian succession that came up now, that Russia might not be the legitimate successor of the UdSSR?
Yeah, that was a very smart observation by Zhonghua. I saw it appear. The trick is that Russia is not the legal successor of the Soviet Union. In fact, it was for that reason, so they would not have to reapply for membership. This is what in the end small Yugoslavia had to do. And then you have to again meet the condition of peace-loving nations, Article 4. But Russia, also because of all the nuclear material here and there, so the international community was, after the Cold War, very interested in having at least one continuation of the former Soviet Union, and reportedly they put a lot of resources invested a lot of resources to make Russia be that continuation, and hence there is no new test of its suitedness for or its meeting certain criteria. So clever question, but also a clever move already some decades ago on this.
Thank you. If we move to the judicial side of things, from the political bodies of the UN, Security Council and the General Assembly to its main judicial organ, the International Court of Justice, André Nollkaemper already alluded to the cases and what they might mean for the state, how they interact, the judicial proceedings with this law on the state of state responsibility. Geraldo, Vidigal, what is going on at the International Court of Justice? What judicial avenues is Ukraine seeking in its lawfare, if I can put it like that, or in its strategies to counter the Russian aggression? Geraldo.
Thank you, Ingo. So as most of you have seen, of course, Ukraine has brought the case before the International Court of Justice. The hearings on the preliminary objections requests are going to take place next Monday and Tuesday. So for all those interested, they will be broadcast online. So I suggest that one looks at them. Now, the case that Ukraine brought is interesting. As you all know, the ICJ requires specific consent to jurisdiction in order to be able to pronounce a case. And so normally, or very often, states are left, looking for a basis for jurisdiction. And in this case, the basis that jurisdiction that Ukraine did find was the Genocide Convention. And it is interesting because what is happening is not that Ukraine is accusing Russia of violating the Genocide Convention. What Ukraine is doing is arguing before the court that Russia's accusation that Ukraine is violating the Genocide Convention is false. And so on this basis, it's asking a declaratory remedies or determination that Ukraine is not violating the convention, and prior to that, provisional measures. Now, this is interesting because of a number of raised a number of legal issues that have been coming up before the court over the previous years and decades, which are first, is a state allowed to do that, to seize the court in order to obtain a clarification that it's not violating international law? One could say, well, is this a real dispute? Because the court, you cannot just bring an abstract disagreement to the court. And here I would say that given, especially that Russia has taken action in pursuit of its determination, then it seems clear that this is a dispute. The second issue is whether preliminary objections are due. And for here, the court only needs prima facie jurisdiction. Right. So, and the court has been quite liberal, let's say, in granting provisional measures in order to avoid the escalation or the aggravation of the conflict. So I don't see that not happening in this case. Whether it's going to be compliance with it is of course a different matter, but it adds to the international pressure, and it gives, let's say, to the extent that what is missing is a binding obligation, then the provisional measures granted by the International Court of Justice are, at least according to the court itself and the current perceptions of it, are binding. Now, it gets more complicated when we get to the stage of the decision whether there is jurisdiction. And that's for two reasons. First, the Ukraine would have to show that there is a dispute regarding the interpretation and application of the Genocide Convention. And why is that a problem? Because there is distinction that the court has drawn in previous cases, and here I'm thinking of Croatia versus Serbia, between the dispute, the customary international law rule prohibiting genocide and the prohibition of genocide under the Genocide Convention. Now, if we feasibly, Russia could argue that didn't accuse, so it has been on record multiple times accusing Russia, Ukraine of committing genocide in these two now breakaway regions of Donbass and Luhansk, but it hasn't accused Ukraine explicitly of violating the Genocide Convention. So the question then will be for the court whether, in order to have a dispute regarding the convention, you need to have a dispute regarding any elements that would be covered by the convention, or whether the dispute needs to refer specifically to the convention itself. Now, I don't think this would be an issue. It will be an issue, but I don't think ultimately this objection would hold, because we couldn't go back to Nicaragua. So there are two parallel rules, right? One under customary international law, one under treaty law. The two rules exist independently. However, to have a dispute regarding the Genocide Convention, you need to have a dispute regarding this, let's say, the substance of the crime of genocide. That would be a sufficient threshold. So in this case law, when you look into it, what the case law says, that's a case law concerning the Convention on the Elimination of all forms of racial discrimination, that in some cases the court has said, well, there is no dispute regarding the convention, but then it is clear to say that a dispute needs to cover the substance of the convention and not the form. So I think this will be the main question at the stage of jurisdiction. And then, of course, at the stage of the merits, the court will have to determine whether Russia can be, what kind of remedy to give. And here, I think Ukraine hasn't gone far enough, in my humble opinion, because it could have asked the court to also state that, or provide that measures of reaction chosen by Russia are inappropriate, and by being inappropriate, unlawful. So it would be, well, if you do have a dispute regarding the Genocide Convention, again, that would be the thing I think Ukraine could have argued, is that you could not respond unilaterally. You would have to go to the court. The provision on jurisdiction states that parties that have a dispute regarding the interpretation or application of the convention shall bring a dispute before the International Court of Justice. And maybe more importantly than this, that the measures of response selected do not fulfill the requirements for countermeasures under customary international law or the ILC articles. And saying, well, and then of course this would require a sort of leap from the convention itself. It'd say, well, if the court has jurisdiction over the convention, it also has jurisdiction to decide on whether measures adopted in response to an alleged violation of the convention are lawful. And here there would be unlawful both because they didn't fulfill the procedural requirements associated with countermeasures. So there was no previous request for Ukraine to stop. There is no announcement of what the countermeasures would consist of. And then, of course, because they are both disproportionate and involve a violation or a disregard of obligations that countermeasures cannot be used, that the use of countermeasures doesn't allow one to disregard, namely the use of force and basic human rights. Thank you.
Yeah. Thank you so much, Geraldo. Very interesting. So, I mean, also to be clear, so the court, the International Court of Justice, placed in the Peace Palace in The Hague in order to exercise or to be competent and then to exercise its competence, its jurisdiction, need a specific basis. Here, the basis that Ukraine invokes is the Genocide Convention because it has that compromissory clause that would give it the jurisdiction, and therefore it couches its claim in the language of to the domain of the Genocide Convention. So unfortunately, Ukraine cannot appeal to that court to say, look, Russia is responsible for a crime of aggression. But based on that Genocide Convention, you're suggesting, Geraldo, that it might have gone a little bit further to say, you know, in that direction, that its measures in reaction to the wrongful, in Ukraine's views, allegations of committing genocide are also disproportionate or even illegal. Yeah, pushing the or giving the court perhaps an opportunity to pronounce itself on that real issue in a way. After all, that the court has oftentimes been rather cautious in that regard. So, in the interest of time and also to give space to the issues that we at least flagged, I mean, there won't be exhaustive, but there is, of course, a very important issue of what happens, what rights the civilians, the people have who are forced to flee. Who are forced to abandon their home, many of their possessions, because they are persecuted, because they fear for their lives, and they cross the territories. Either they seek refuge within Ukraine, or they cross the borders and continue to Poland or into Germany. I think yesterday 2,000 refugees arrived in Hamburg, where I am at the moment, and so on and so forth. So I would give first our professor of refugee law, Marijoleine Zieck, and our expert in European migration law, Marten den Heijer, the floor of the roundtable. Marijoleine Zieck, please, would you introduce us to the refugee law that pertains to the protection of civilians, of refugees here in this conflict? Thank you.
Thank you, Ingo, and good afternoon, everyone. I will say a bit about how many, legal status, but also about sharing of responsibility before I give the floor to Maarten. First, the figures. I mean, it's hard to keep track because, you know, whenever you write a figure down, it is, you know, the next hour it's different. We're talking now about an exodus of over 1 million refugees, half of whom fled to Poland. And the others fled to Hungary, Moldova, Romania, Slovakia, and other European states, including Germany, but also Netherlands. But interestingly enough, also 48,000 to Russia and a few hundred to Belarus. The exodus consists predominantly of Ukrainian citizens, mostly females with children because of the conscription of males in the Ukraine. Secondly, the exodus also consists of refugees who enjoyed asylum in Ukraine. And thirdly, there are foreign students who leave the country. I have no idea how many succeeded in fleeing. I was referring to refugees hosted by Ukraine. As far as I could find a figure, it's about 5,000 refugees. And that includes a number of about 700 Afghan refugees who were evacuated last August. So I just want to mention them, but can you imagine you escape from Afghanistan and you end up in Ukraine? Their situation is especially difficult, I would say, because they were still being processed for, identity, refugee status, and so on. So they don't have papers and they fear getting access anywhere else now. As to the exodus, I think a very positive aspect is the way it's handled now. The refugees or the displaced persons are extended a very warm welcome, even by states such as Hungary, which we really came to know as a state is pushing back and maltreating refugees. I just have to refer to a series of judgments of the European Court of Human Rights. A negative aspect of the warm welcome is that it was not extended to everyone. Foreigners and refugees, among them blacks, were discriminated at the borders, blocked when trying to gain access to another country. White Ukrainians prioritized. Some Black refugees, there was even footage on the Dutch TV, they were pulled out of trains, making place for white Ukrainians. Illustrative, I would say, for the differential treatment are the statements made by Bulgarian Prime Minister. I would like to quote them. And I start, "These are not the refugees we're used to. These people are Europeans. These people are intelligent. They are educated people. This is not the refugee wave we have been used to. People we were not sure about their identity, people with unclear pasts, who could have been even terrorists." End of quote. Thoughts such as these may explain the warm welcome referred to, but it stands in stark contrast to the way Europe responded to the influx of refugees in the previous crisis, which was the one caused by the Syrian war. They were barred from entry into the EU. I just have to refer to the EU-Turkey deal of 2016. So what about the status of those who leave Ukraine now? The Ukrainian refugees do not satisfy the definition of refugee comprised in the 1951 Convention relating to the status of refugees, because that focuses on persecution, and the Ukrainians do not have a well-founded fear of persecution on the hands of the Ukrainian authorities. But they do fit the wider definition of refugee UNHCR applies, and UNHCR applies that wider definition usually outside of Europe. And that includes persons who flee serious and indiscriminate threats to life, physical integrity, or freedom resulting from generalized violence or events seriously disturbing public order. Having said this about not fitting into the 51 Convention now, that may well change if Russia gets hold of Ukraine, occupies it, and then all those refugees who are outside now may well turn into refugees in the sense of the 51 Convention. So it's not that it is a temporary not or indefinite non-fit into this convention. It really depends on what's going on the ground. I would like to say something about responsibilities here. UNHCR now indicates that there may be many millions of refugees pouring out of Ukraine. It even expects like 4 million refugees to coming weeks. Fortunately, their leaving Ukraine will be made easier because that is some of the few things Ukraine and Russia could agree upon. There will be humanitarian corridors, so at least they can leave safely. We'll have to see that. So one question that should be addressed is how the responsibility to look after and protect the refugees or displaced persons, however you want to call it, how will that be shared? At this moment, Poland hosts most of the refugees. I don't think we cannot expect Poland to bear the brunt. I mean, perhaps there are 4 million later on. The temporary protection directive, which Marten told me has already been activated. I was not sure whether it would be or has been, but apparently it has already been activated. It does comprise something along the lines of distribution, but it is a voluntary system, and it has for that and other reasons been qualified as a critical weakness of the temporary protection directive. But the temporary the protection directive is something Maarten will discuss now.
Yeah, thank you so much, Marjoleine. Marten.
Thanks, Ingo. Good afternoon, everyone. I think Marjoleine addressed the key points. I'm the final speaker of today, so I will also restrict myself a little bit. Specifically, I want to talk about the EU response to the exodus, as Marjoleine rightly coins it, on two issues. The first is the border. What is happening at the border? How open are those borders, and how open should they be? And I think that is a pertinent question. We have already heard stories of Ukrainians or persons in Ukraine deciding not to flee because of the chaotic scenes. The second issue I want to address is indeed the status of persons who manage to cross into the European Union, including the activated temporary protection directive. Firstly, about the border, and then I could concur with Marijoleine that we have seen some questionable practices of differential treatment. This is an area, this is very densely regulated by European law, of course, how to control our common borders. Key is the Schengen Borders Code. Importantly, the Schengen Borders Code does allow for two very important derogations, which were immediately set in motion by most of the Eastern European member states. The first is the possibility to check persons less thoroughly. Normally, persons should be checked against certainly third country nationals, including Ukrainians, against all sorts of databases. They must meet all sorts of entry conditions. The European Commission published a set of guidelines of 8 pages last Wednesday morning, setting out, advising member states how to make use of the derogations. Now, there are essentially two. First, less thorough checks. What the European Commission advises is that certain categories of persons, including EU citizens, but also Ukrainian nationals with a biometric passport, vulnerable people, should only be checked for their identity and being registered. Other persons may be more thoroughly checked, but the European Commission advises to do that away from the border so that the flow remains as seamless as possible. So this also explains why there are still chaotic situations. It is easy to say, let's open the border to everyone, but these may be persons who have been served entry bans by member states. These may be persons without documents. So some control and some check must be conducted upon every one of them, unfortunately. But I think we can only be happy to see how the attitude, how welcoming it is, as opposed to the attitude only a few months ago with respect to migrants from Belarus. The other relaxation or derogation in the Borders Code, which the European Commission advises to use, is to simply waive the entry conditions or consider waiving it for everyone exiting Ukraine into the European Union. And this is also the derogation that normally applies if one asks for asylum at the external border. The derogation says, well, entry conditions may always be waived for humanitarian reasons or for international obligations. It is, of course, also an international obligation to not refuse entry to persons in these circumstances. So across the board, one can say that what is normally a regulation that should very, very strictly be applied by the member state is derogated to a considerable extent now at the border with Ukraine. There is certainly room for discussion. Following up on what Marijoleine says, the Borders Code does not say in respect of which persons exactly and which entry conditions exactly can and may be waived, and it is concerning to see that there is differential treatment, perhaps on the basis of resident status, perhaps even on the basis of skin color. Let me now move on to the second issue, which indeed the EU Justice and Home Ministers discussed yesterday to activate the Temporary Protection Directive. It is the first asylum directive agreed on by the EU once it became competent in this area in 2001, but never activated. It has been regularly suggested to activate it in response to the Syrian exodus, but those times it were primarily the Eastern European member states which were not in favor of it. The Commission proposed to launch, set in motion the directive only last Wednesday together with the guidelines I just mentioned. And yesterday, unanimously, the Justice and Home Affairs Council agreed to set in motion the directive. Only qualified majority was required. Initially, Hungary said it was opposed to the directive. It did not want to have any EU involvement in how it was to be treating the refugees. Poland initially also had reservations. It said we only want the directive to work for Ukrainian nationals and not for persons with other nationalities fleeing into our territory. The compromise in respect of personal scope, the final text is not out there, so I have to do it with what some people have told me and what's in the press. I believe the compromise found is that under the scope of that directive are all Ukrainian nationals and persons who enjoy long-term residence in Ukraine, so that may include persons who have been granted refugee status, Excluded from its scope are persons with short-term forms of residence in Ukraine, such as students, and they are expected to be repatriated to their countries of origin. Why is this directive important? Well, firstly, because it disallows the need for asylum procedures. Obviously, it's impossible to conduct more than 1 million asylum procedures coming in a week. Initially, it was thought, well, we do not really need asylum procedures, and we also do not really need special status because most Ukrainians have visa-free travel. They are allowed to circulate freely within the Schengen area for 19 days, but this only concerns Ukrainians with a biometric passport. Nothing is said about non-Ukrainians. Moreover, it expires the right to freely move within 90 days, plus the right to freely move, okay, but it says nothing about social assistance, accommodation, healthcare, education, all those issues that are normally associated with an asylum status. So for those reasons, it is important that the directive, it has been agreed to activate the directive. Marijoleine, your question, I don't know when it will enter into force. The Commission proposal says that if adopted, if it enters into force, it will apply retroactively to all persons who have fled Ukraine since the 24th of February. What status? Right to residence for at least a year can be extended up to 3 years. All the basic amenities and services that are normally associated with asylum seeker status, I should say. So access to accommodation, right to work, very important. Family unity is also important. Education, healthcare. If you ask me to be critical about this directive, perhaps 2 points of criticism. First, according to the directive, the status is not as strong as refugee status. Refugee status is normally treatment in respect of all those socioeconomic entitlements on par with nationals. And this is more akin with asylum seeker status, so no full rights of socioeconomic participation. I don't think that it is a problem right now, but if indeed the war continues for a long time, Ukrainians will try to build their lives, will want to build their lives. They do not want to be in a reception center dependent on aid of government. So it also depends how member states have implemented this directive. In the Netherlands, it was a very narrow implementation, asylum seeker status, but member states are free to grant a more fully fledged asylum status, but this may differ per member state. And another issue you also talked about it, Marijoleine, is that the directive itself and also this council decision to activate it is very silent on solidarity measures. Up to now, this is also because there is visa-free travel. It's simply up to Ukrainians to choose to which member state they want to go. They have the right, if they enjoy the right of visa-free travel. The European Commission is saying we are monitoring closely the situation, and indeed, if Poland or other member states are becoming overburdened, we must come together and think about relocation or other modes of assistance.
But Europe has a very bad track record in relocation for solidarity. I mean, I just have to refer to Greece and Italy, and it didn't work properly. If I may, Ingo, can I have one question for Maarten?
Sure.
I was just wondering, because I have a bleak prospect, or bleak, well, I'm not pessimistic about what's going on or in the long run in Ukraine. So what if this goes on for a long time, and those 3 years, which is the maximum, are over? What then? What then? I was just wondering if there are any thoughts on the part of the European Union about what's next.
The idea is that after 3 years, if it is still impossible or unsafe to return, ordinary regular asylum procedures should be started. It is, I think, also good to mention that the directive gives persons included in the scope of this directive also simply the individual right to ask for asylum. And the Netherlands has implemented in a way that, well, if a Ukrainian national in the Netherlands will ask for asylum, we will suspend our decision on the claim until the period of temporary protection ends, and then we will entertain the asylum procedure. But this is again something that member states may have different laws about.
Thank you so much, everyone. I'm afraid that we do need to wrap up. It's been a great treasure, relative fortune to have this collective shared expertise that we could introduce this afternoon and share this afternoon. Thank you, all the participants in the roundtable, all the participants in the webinar, for your questions, active participation, for listening. We have heard of a lot of unification in light of the clear act of aggression by Russia against Ukraine. All but 5 nations, including Russia, united for peace globally. Also, Europe has united, pursuing its humanitarian obligations more meaningfully, but not without divisions that remain, such as those that are evident in the treatment of refugees and the separation at the borders, basically practically based on their skin color. Let us hope that unity prevails in light of this aggression and in light of injustice, that it prevails to relieve at least some of the suffering that is inflicted by the war. Thank you, everyone, for participating. Thank you for listening. Have a good remainder of the day.
Thank you for moderating, Ingo.
Thank you, Ingo.
Thank you very much.
Thanks, Ingo.
Thanks, everyone. Thanks.
Thanks so much.